Hi, my name is Amanda Rocha. I am an estate planning attorney in California, and today I am going to talk about durable powers of attorney. Before I get started, I wanted to give you my contact information in case you wanted to reach out with any questions. You can comment down below, or you can go to my website, www.amandarocalaw.com, or reach me through Facebook or Instagram at Amanda Rocha Law. Now, a durable power of attorney is a legal document in which you would designate an agent to act on your behalf for financial matters in case you become incapacitated. That's about as simple as I can make it, but let me break it down for you and provide a little more detail. Before I do that, just know that a durable power of attorney is for financial issues only and does not cover healthcare decision making. In California, we use a document known as an advanced healthcare directive for healthcare decision making, and that does not have to be the same agent that you have for your financial decisions. Many people choose the same person for practical reasons or otherwise. However, just know that they do not have to be the same person, and they are separate documents with separate powers. Now, for a durable power of attorney, the first thing you're going to need to know is who's your agent. You can choose a person to act immediately, or you can choose that person to only retain power once you become deemed incapacitated. And there's another layer to that. So first, if you have the person acting immediately, that does not necessarily mean that you can't also make decisions for yourself. If you are able to, per California's law, of capacity, if you meet the capacity laws and you are able to make your own decisions and you have the wherewithal, both of you would have the power to make decisions on your behalf if you choose to have that happen immediately. Some people choose to do this if they have ongoing health issues and are incapacitated from time to time. Other people choose to do it immediately if they want someone to step in because they expect something will happen to them soon. Otherwise, a vast majority of people choose to have their powers of attorney with a springing power, which means that the person that they choose, their agent, will not have any power to act until they are deemed incapacitated. Now, they can be deemed incapacitated in different ways, and you get to choose that in your power of attorney form. First, you can choose whether you want that person whether you want yourself to be evaluated by one doctor, by your general practitioner, or by two doctors. You can even have it so that a judge has to say you are incapacitated. And whatever way you choose, once that happens, your agent will be able to act on your behalf. The next question is going to be, what are they able to do? That is also up to you. The form allows you to be as specific or as broad as you'd like. You can limit their power in many different ways, or you can actually put no specifics at all and allow them to make any changes that are necessary for your well-being. Something you need to know is that a power of attorney is only good while you are living. So if you pass away, that person who had the power of attorney no longer has the power to act, because there is nothing for them to have power over, in that case, it's either going to be your trustee or the conservator of your estate that is able to make decisions for your estate at that time. Let's see. As far as a durable power of attorney goes, there are many ways to obtain one. There's a form on the California Judicial Council website that is created for you by the legislature of California that is supposed to be accepted at financial institutions. I am here to tell you, as an attorney with experience dealing with these, that even the statutory form is not always accepted. It depends on the bank you go to, it depends on the employee you speak with, and on the action that you are taking. And sometimes this is an easy thing for you to get through, and sometimes it's not. There are other forms you can fill out from various different websites. Just know that if you're downloading this form, not only are you not sure exactly how to fill it out and what everything might mean, but let's say you do fill it out, it might be an old form unless you get it from the Judicial Council website. So be very careful if you're going to do this on your own. I would advise you to speak with an estate planning attorney who can explain to you exactly what you're doing and filling out, and make sure that if you want the powers to be limited in any way, that is done correctly. And if you want it to be a springing power as opposed to immediate, it's filled out correctly. And in addition, if you have had an attorney help you fill it out, when push comes to shove with the financial institution, if they give you issues with it, the attorney can then help you or help your agent get to where they need to go and explain to them what the document is and why it's correct. Whereas if you do it on your own, there might be an issue because not only would you not have access to an attorney who filled it out for you, but it may have been filled out incorrectly. Your agent is not going to necessarily have the power to speak to an attorney and hire one on your behalf as well. So it can be very complicated. So as I said, be wary of anything you download on the internet, always, regardless of what the documents are, and seek legal advice for your very specific needs, because every person's document is going to look just a little bit different. If you have any questions, comment down below, or send me an email or a message as I mentioned at the beginning of the video. Thank you.